Welcome to the Nebraska's Division of Developmental Disabilities training presentation on Developmental Disabilities Court Custody Ordered Act, or DDCOCA, for providers. My name is Tanya Nankus, and I am the division's training coordinator. And with me today is Dr. Tessa Sabota and Nebraska DHHS attorney Cherie Hatfield. They are our experts in the field and presenters for today's training, which focuses on DDCOCA as it pertains to providers. To begin our presentation, we welcome Dr. Tessa Sabota. Hello and welcome.
Thank you. Okay, so let's start talking about why this training in this area matters for providers. It is important for providers specifically because we need to ensure that the treatment and program compliance is all compliant with what is written in the court orders. We need to be aware of what will happen if there are consequences of not following court orders. Information about court-related activities and procedures, as well as advocating for individuals with the courts. We are doing a few different types of presentations, sharing information with different populations in order to enhance the communication between all parties in these cases. We are specifically doing a DDCOCA presentation aimed more at the justice system to make them aware of the regulations that we are required to deal with on our side that they may not be aware of. So part of this, it's important to understand where the courts are coming from as a provider, so we understand not only what we need to follow, but if we truly need to advocate for our individuals with the courts, what are the best ways to do that? How do the courts look at these cases? And becoming more aware of how we can better advocate for participants.
Hi, this is Cherie. I'm going to talk a little bit about the purpose of the DDCOCA. We call it DDCOCA for short, but it is in long the Developmental Disabilities Court Ordered Custody Act. The purpose of the act is set forth in Nebraska Revised Statute Section 71-1102, and it basically articulates this need to balance the right of individual liberty against public safety. Specifically, 71-1102 says there are instances in which the threat of harm to others in society is sufficient that a court should balance the right of such person with the interests of society and place care and custody of such person with the state of Nebraska for appropriate treatment and services. A lot of the time, working these sorts of cases can take a shift in thinking. Normally, we consider treatment to be a voluntary option for individuals who are, struggling with mental illness or mental health things. But in this case, a lot of the time you are dealing with an individual who doesn't have that choice, is being involuntarily made to participate in services, or could be involved in some sort of criminal case where involuntary services are sort of predicated on, them trying to avoid a harsh sentence or something like that. And so it is often, sort of the responsibility of the treatment team and providers to sort of be aware of the public safety element that is being sort of balanced in these cases, so that way we can make sure that not only the individual but the public as a whole is also safe from whatever the harm that is kind of thought of when it comes to DDCOCA. It's also important to sort of know that DDCOCA is distinct from the Mental Health Commitment Act as well as the Sex Offender Commitment Act. Those are separate statutes and they have different rules. And we're going to talk a little bit more about the Mental Health Commitment Act here. This is just a quick breakdown of sort of the differences between the two acts as a sort of quick reference, if you will. But essentially, they are initiated in much the same way by someone in the community contacting the county attorney and letting them know that there's an individual who has some sort of illness and is dangerous. Now, you can see here on this slide that the difference is that for the Mental Health Commitment Act, they have to be determined to be mentally ill, so they have a mental health diagnosis of some sort. But for DDCOCA, we're looking at a diagnosis of a developmental disability, which is a very specific, very narrow sort of definition that Dr. Swoboda will talk about here in a little bit. The other big difference between the two is that Mental Health Commitment Act kind of encapsulates danger to self, such as suicidal ideation, as one of the possible dangers that need to be protected. But for DDCOCA, that is not the case. It only encapsulates situations where the individual is a danger to others. They are heard by different parties. The Mental Health Commitment Act is usually heard by a mental health board in a county where the individual resides, whereas DDCOCA cases are heard by a district court judge. They both do use the rules of evidence mostly. There are a couple situations under DDCOCA where they might not apply. And they do encompass different evaluations. So under the Mental Health Commitment Act, it just requires an evaluation by a mental health professional, and it doesn't necessarily happen as part of the proceedings unless it's requested. Whereas with DDCOCA, there's always an evaluation by the department in every case when it's instituted. So it's just sort of interesting to see how these two laws basically are very different from each other, but they sometimes can be conflated as if they are the same. And now Dr. Spoda is going to talk a little bit about the trend in the state of Nebraska.
So, the developmental disability court-ordered custody commitments by year. The act was first initiated in 2009. I think it was 2005 when it was enacted in law, but the first case began in 2009. And this shows the number of individuals who were ordered under court custody per that year. So it is not a cumulative number. It does look like it is increasing based on this. However, I do not believe this is due to an increase in violence. I think it's much more an increase due to awareness of this as a possibility for people. Since probably 2015, definitely 2017 on, the clinical team has become much more involved in how to handle these cases, trying to standardize the process, not only for the courts, but for the individuals and the providers, and have it make more sense to everybody. We started doing presentations to certain county attorney groups. So I think this increase that we are seeing right now is related much more to awareness that jail is not the most appropriate place for these individuals. And in fact, it can be even more detrimental at times. So as they're becoming more aware of this and using it more, providers are more likely to interact with an individual who is subject to the DDCOCA. I think we have not added it as of yet, but at this point, there were 3 added so far in 2023 as well. I think the current total is right around 45 statewide. Okay, so I'm going to breeze through a lot of this because as providers, you are somewhat familiar, with the current regs and regulations. So in order to be eligible for services, whether it is through the DDCOCA Act or through normal waiver services, the regulations are the same. It has to be a developmental disability manifesting before the age of 22 years, likely to continue indefinitely, and results in substantial or significant functional limitations in one of each of the following areas: conceptual skills, social skills, and practical skills. So this means someone could potentially have a diagnosis of autism, which would meet this criteria. It would be attributable to the mental impairment, manifest before the age of 22 years, likely to continue indefinitely. But if they are someone who has had strong supports or has a lot of strength, they may not meet this criteria, which is evaluated using standardized adaptive assessments, nationally recognized assessments that are scored on the same scales as the IQ tests. So they have to have a developmental disability. They have to have substantial limitations in conceptual, social, and practical skills. And this is just kind of the general one, reflects the need for combination and sequence of supports. According to our statutes, intellectual disability is defined as a score of 70 or below on a valid IQ test. This is not how it is currently defined in the Diagnostic and Statistical Manual. This is how it is defined, however, in our statute. So in order to establish that intellectual disability, the state is looking for an IQ assessment with scores of 70 or below. Preferably more than one, establishing it wasn't a weakness at one time. Maybe due to mental health depression, lowering that. But in these cases, there's usually quite a few assessments, especially through schools. And this is the same as our substantial limitations, or substantial limitations is how it's described in the statute. Basically, because the statute does not descriptively state what that means, we take the fact that adaptive results and IQ results are measured on the same scale, the standard scores scale right down here. And all of these are measured on what we call a bell curve, where the middle of the bell curve is where most people are, between one standard measure above or below. It's about 68%. When we say substantial limitations or significant limitations when using the standard scores, this is defined as a 70 or below, or 2 standard deviations below the mean or the average. That's a lot of kind of complicated language to basically say, because IQ tests are measured and defined this way, this is exactly how we also judge the adaptive scores.
So least restrictive alternatives is a primary component of DDCOCA. Basically, any treatment that is being ordered or placement always has to have in mind what is least restrictive to the individual's liberty. So 71-1109 essentially is attempting to balance the 3 different interests in order to reach least restrictive alternatives, which is the individual's autonomy, their right to freedom, their treatment needs, so what is appropriate to their specific diagnosis, and the need to protect the social to protect society and the public at large. And so you can kind of see in that diagram, we're looking at that sweet spot in the very middle. Now, with DDCOCA cases, generally the emphasis is always going to fall more on the side of protecting others. because of the involvement of the court as well as county attorneys. That is mostly going to be their focus just by virtue of that's what they do day in and day out. And so sometimes as providers, it can be necessary to emphasize the other two elements, which is what is the appropriate treatment for the individual's condition, and then what is their right to autonomy or individual freedom, essentially. Because sometimes there needs to be someone to sort of point that out or emphasize that when you're doing reports or documentation, so that way people don't forget that those two are also sort of in the balance, as we are discussing these things, because the court is supposed to take least restrictive alternatives into consideration for all the decisions essentially that they're making that infringe the subject's ability to make their own choices. And so, we want those to be as unobtrusive and restrictive as possible to maintain these three elements, but primarily protecting other people. And as providers, even though DDCOCA, for purposes of putting the person in custody, doesn't take into consideration risk of harm to others, but once they're in your care, you do also have to obviously, be concerned that whether or not they're causing harm to themselves. And so that is also kind of encapsulated in this assessment, is that sometimes restrictions need to be placed also for their own therapeutic good. Um, and so making sure there's good documentation about, incidents and things like that can really underscore this element.
I think that is the best thing you said so far, especially documentation, because their emphasis is on protecting society. And we are going to, as the treatment team in the division, we kind of need to work with the courts to justify either safety, the need for some of those restrictions, or maybe the need for reduction of some of those current restrictions that we have in place. The courts will respond mostly if we have clear documentation. Cherie had just mentioned when talking about the Mental Health Board Commitment Act versus DDCOCA, Mental Health Board Commitment Act does cover harm to self or harm to others. DDCOCA is very specific in threat of harm to others. They're also very specific about what it means to be that significant likelihood of substantial harm. It has to be serious bodily injury on another, attempted to or actually inflicted, sexual assault or attempted sexual assault, attempted fire starting, as well as potentially using a weapon, damaged or destroyed property, put another person at risk of harm, or injured another person. It has to be fairly significant risk of harm to others, and it has to fall in one of these categories in order for the person to be placed under DDCOCA.
And at this point, it's a good time to remind folks. As providers, you're dealing with a set population, and so sometimes we can kind of get caught in sort of a narrow focus and forget that by and large, individuals who have developmental disabilities or intellectual disabilities, or even mental health diagnoses, because those can be co occurring, are not more likely to engage in violence. Sometimes with these conversations, it can become sort of glossed over, I guess, that in society, what we actually see is that individuals with intellectual or developmental disabilities are not more likely to be violent. They're actually about 4 times more likely to be victims of violent crime. And so I've given some statistics here that just sort of, underscore But then also, I want to talk about the reason for victimhood is likely because of they are at increased risk. But there also can be some difficulties with sort of mischaracterizing behaviors for the individuals who have intellectual disabilities and developmental disabilities. They can be seen as argumentative or not responsive. Anyone who has a family member or loved one who is maybe on the autism spectrum can kind of understand that sometimes their response and reaction is not um, what we would consider typical, if that makes sense. And so what could be an appropriate response to them may seem argumentative or non-responsive to the individual who's engaging with them. Individuals can exhibit socially inappropriate behaviors such as standing too close or stimming in ways that seems worrisome to an onlooker who's not familiar. They can appear to be anxious or agitated, which we can mischaracterize as signs of guilt um, or aggression because of the types of agitated behaviors, like waving arms around, pacing, quickly, things like that. There can be behaviors such as screaming, talking to oneself, or self injury, such as like smacking their palm against their forehead, or even hitting their head against a wall and things of that nature. It's kind of important to note that as a society, we tend to have preconceived notions and biases that individuals, um, you know, are likely to be more violent, even though the statistics don't bear that out. And so I've added in here, that there was a study that indicates that 23% of jail inmates report having cognitive disabilities. Um, and, it's possible, uh, if not likely, that maybe it's something that we as a society need to continue to deal with is our mischaracterization or misunderstanding sometimes of the way that individuals communicate and behave. Um, on the next slide, it talks about victim risk factors, which I had just mentioned a little bit. Individuals are about 4 times more likely to be victims of violent crime, which includes sexual abuse. The reasons for this can be because they may have deficiencies in their sexual knowledge or impaired judgment. You may encounter that they, want to get married and have a family, but do they actually understand sort of the steps of that process, if that makes sense? And so sometimes with their lack of knowledge or, not being able to understand social relationships, there can be, a big risk for being victimized. They can be also victims of physical, financial, and emotional abuse because of their dependence on their caregivers. It's a very close relationship and a lot of, sort of vulnerability in being dependent in that way. Sometimes when there are multiple caregivers, there can be sort of a lack of continuity of knowledge about what's happening. And so that can open them up to more risk. They may have limited communication skills or behavioral difficulties that sort of obscure people's ability to hear them or understand them when they are trying to make reports about things that are happening to them that make them uncomfortable or unhappy. And they also tend to live and work in high risk environments. And so all of those things make them more likely. And as providers, especially, it's our duty to protect people in our care. And so we need to sort of keep an eye out and be suspicious, or at the very least curious, when an individual is saying something that maybe raises a bit of a yellow flag, if you will. That they don't like a certain staff member, maybe that's indicative that something's happening and that we should be curious about what it is, instead of just passing it off as this is an individual who has behavioral problems and makes stuff up, for example. I just always want to point this out because the higher likelihood of victimhood is a bigger deal, in some ways, or at least more of a likely risk than them committing violence against another person is necessarily.
I think this is one of the biggest things for providers to start kind of looking at from all angles with these individuals. The majority of individuals who fall under the Court Custody Act tend to be individuals who are quote unquote slightly higher functioning, have more social abilities, have more practical daily living skills abilities, still not quite enough to be out on their own, obviously. Um, and this perception can go both ways. These individuals tend to have a history, obviously, of violent behavior if there was a charge, if they're under the Court Custody Act. People may tend to focus more on them being the victimizer. Um, we need to keep in mind that they might also be the victim. So they may have friends come over who are not in services, um, girlfriends who want to stay the night. It's not that this is absolutely not allowed by any means, but it is something that we need to pay attention to. Um, Keeping in mind that they are in services for a reason, and we need to make sure we protect that individual as well as the public. If that person has a history of sexual abuse and you're letting a random girl go in the bedroom with them, um, maybe check an ID beforehand, make sure she's at least over 18. There are different things that can be put into place just to make sure that there's not victimization on either side. Not assuming someone can't be victimized because they victimized others. So just try and keep an open mind looking at it both ways. Not only how could they potentially be a risk, but how could this situation be a risk to them given their vulnerabilities?
So, as a quick procedural overview, you can sort of see how the flow of these cases happens. It usually starts with initial contact, which generally is going to be law enforcement being engaged with this individual, but it isn't always. Sometimes it can be initial contact is with a family member or caregiver who is having difficulties with their loved one or their family member. But whatever the contact is, someone then reaches out to the county attorney, and the county attorney files a petition. There is the option at the stage of petition to file for emergency protective custody. That's what EPC stands for. But emergency protective custody can also be in place prior to the petition being filed. It's sort of flexible in that way, and it will just sort of depend on the facts of the case. Once the petition is filed, the department completes an assessment. um, Once the assessment is completed, there is an adjudication hearing, which is basically to handle the question of whether or not the individual falls within the DDCOCA, developmentally disabled and dangerous category. If the court decides that they are, then they proceed to propose treatment, which usually requires a little bit of time. And then once the proposed treatment plan is in place, we move to disposition, which decides, sort of the ongoing treatment plan and placement for the individual. And then there's review hearings. And as you can kind of see in this flow chart, sort of at any point from the petition being filed onward, the case can be dismissed at motion of any of the parties, including the county attorney. But just sort of as a quick reference, this is sort of how the process proceeds. And we're going to go into more detail here in a second. So the petition itself, you may, not need to know this as a provider, but it's in here for a reference. So that way you might understand why you're receiving notice of things if you were provider prior to the filing. So the petition is filed by the county attorney. I know it says the attorney general can file, but it's very unlikely that they will. I've not heard of a case where they filed. It's almost always the county attorney. The contents of the petition will be basically the demographic and information of the individual, their name, their address, their age, any addresses of guardians or close relatives, a statement of their developmental disability and the harm posed to others, as well as facts to sort of back that up. So it's not enough to just say that they have a developmental disability and pose a threat of harm. There has to be some sort of specifics in there. Next slide, please. Additionally, this is then filed with the district court in the county where the individual resides or where an alleged act that was the threat of harm occurred. So essentially what this would mean is, like, say for instance, you have an individual who's a resident of Douglas County, but they go to Sarpy County and they start a fire in somebody's backyard for whatever reason, but they have a developmental disability and they do that. In that case, the petition could be filed in either Douglas County, because that's where they reside, but is more likely to be filed in Sarpy County if they are, for example, cited or arrested for setting that fire. Because the cases would basically run concurrent, where they would have a criminal case for the arson potentially, or whatever crime they decide to charge them with, maybe public nuisance or something. And then also the DDCOCA. So then they would run sort of parallel to each other, though often the criminal cases are dismissed once the DDCOCA is in place. A copy of the petition is served on the subject, their attorney, their guardian, their next of kin, if any, as well as any person having custody and control of the subject. So that would be if they were living in a group home or with a provider. That's where you would get a copy. Next slide, please. So as I mentioned, that emergency custody can be taken either prior to the petition or at the time of filing the petition. If it is requested at the same time as the petition, it is filed on an ex parte basis, which basically means that it's a request made to the judge without a formal hearing, without all of the parties present, without all of the parties present, or without advance notice being given to the parties sufficient for there to be a request for hearing. At this point, the department would provide a recommendation for appropriate treatment that would have space and is willing to hold the subject. The department would have to evaluate the subject within 7 days and determine whether or not the individual has a developmental disability and is a threat of harm to others. The subject can request an expedited hearing once this ex parte order is entered, and then a hearing would have to be held within 10 days. This basically comes down to their due process rights, which essentially none of us can be held against our will without good cause, for lack of a better word. And so that's kind of what's at stake here and what's at play when we're talking about the ability to sort of restrain someone temporarily on an emergency basis, for the purposes of protecting the public, essentially, from them. So next slide, please. Oh, go ahead, Tessa.
If you hear about the clinical team referring to a 7-day DDCOCA evaluation, that's what this refers to. It's a very brief evaluation done by the psychologist who just, we're basically looking at not how much of a risk this person may be, but are they a risk? And are they eligible? So this would be a 7-day evaluation that's written by the psychologist. In the other situation where they're not petitioning for emergency custody, that would be what we call the 30-day evaluation, which is also done by division psychologist.
Right. Thank you for that clarification. And like we had sort of talked about, this is all before the adjudication. So the individuals have a list of rights. This is given to them prior to the first hearing, usually. The first and most important one is their right to counsel and to having counsel appointed. As providers, you're probably aware of this because it's always important to facilitate their ability to contact and communicate with counsel once they are in our custody and care. They can have a guardian ad litem appointed to act on their behalf. It is sometimes confusing to people what the role of a guardian ad litem is. Sometimes people think they are attorneys because they, by profession are attorneys. and sometimes people think they are guardians. Guardian ad litems are essentially like a non-interested third party advocate, but not an attorney for purposes of like filing things or actual representation. Their goal is usually to advocate for what is in the person's best interest, rather than necessarily what they say they want. Their attorney is more supposed to do what they say they want. So, I don't want to be in DDCOCA at all. That would be what their legal counsel would be then trying to get the case dismissed or get them released from court custody. The guardian ad litem is going to look at all the facts and information and talk to all the parties and then make a decision as to what is kind of in the person's best interest. Or to assist the person's legal counsel in the defense when the individual is maybe not capable of doing it themselves. So they have sort of an interesting role in that respect, but they also are not decision makers like guardians. And I just want to point that out for y'all, so that way there's some clarity. There was
Sure.
time.
Let me jump in real quick.
Yeah, go ahead.
I had a hard time conceptualizing this when I was first dealing with this situation, especially in the cases where there is a guardian ad litem, and those are two separate people. So in the court process, for any of you who may know Freud's old id, ego, superego theory, this is the best way I can kind of explain it in the courtroom when there is a guardian ad litem, defense attorney, and county attorney. The county attorney is your superego, the one who is absolutely obsessed with rules, and order and wants to make sure all those are followed. The defense attorney is the id, the one who wants whatever the defense wants, whatever the client's telling him, whether it's get rid of DDCOCA, I don't want medication, I don't want anything. That's the id. The guardian ad litem kind of mediates between those two, and helps also provide kind of an outside opinion, kind of taking in those rules, but also some of that desire in the middle. So the guardian ad litem plays the ego mediator role.
Yeah, that's pretty accurate. Yeah, but they don't have a lot of like authority or power necessarily. They're there, like I said, more in like an advocacy role for whatever they think the best interests of the person would be. And so they can be useful. I think they're not very common in these sorts of cases, because they would have to ask for them to be appointed. So you have to actively make a request.
It does depend on the county. I know there is, I think it's Sarpy County that has guardian ad litems often appointed initially in these cases. Some other counties prefer not to unless there's reason to. However, we have worked with legal teams in the past and had a guardian ad litem appointed, for instance, in a case in Douglas County, where we just kind of needed that mediator for the judge, because the defense attorney understood exactly what we were trying to do and agreed with it, but still had to go along with what the individual was telling her.
Right. Yeah, I think their non-partiality, because they don't represent anybody, they're not being paid by anybody. The judges really trust them to sort of be an information gatherer that is non-biased. And I think they're a very useful role. It's just sort of an odd one, to people who are not in the courtroom often to sort of understand or conceptualize. But just so the most important thing from a provider's perspective, I think, is one, they can't consent to anything or give you permission. And two, they are still entitled to access to the individual, the patient, because they need to talk to them and check in on them and get copies of records and things like that. So those are kind of the big takeaways, I think, from the provider perspective, of understanding, why they are involved in what they do. But it is an interesting thing, but they are not a guardian and they are not an attorney that represents the person. And so, as you can see, the individual will have a hearing. They have the right to reasonable continuances. Say if some health issues come up, they can subpoena witnesses and cross-examine witnesses. They can also have their own expert witnesses if they say want to be evaluated by an independent psychologist or something because they disagree. And they are also entitled to a transcript. Now, some of these rights can be sort of affected by restrictions, like, say, communication with their counsel might be restricted if they have, issues with like boundaries around communication. And they're trying to call their attorney 20 times a day or something. Like, there can be limitations on these rights. I just want to point that out. Not all of them,
but not complete restrictions, I'd say.
Correct.
So we would still have to make sure the individual could talk to their defense attorney at some point, but we would be able to do limitations. So it was only maybe once a day or once a week, depending on the situation.
There can be good reasons for it because it can be, disruptive to their lives if they're given free reign to call their defense counsel, for example. But a reasonable restriction would be you can have 2 phone calls in the morning and 2 in the afternoon, and you can choose if that phone call is to your counsel or your guardian ad litem or whoever. You know what I mean? Things like that can be put in place. So it's not unlimited, but those are the sorts of things we would usually want to get approved by the court, just to cover the bases in terms of making sure that it is a least restrictive choice to limit that right. Advance the slide, please. So once we reach the adjudication hearing, which means we've got that evaluation from the department, the hearing is going to be on the petition. The allegations that are set forth in the petition is what the adjudication hearing is all about. It's got to be scheduled within 90 days of filing the petition or 45 days from the date that the emergency custody starts. That can be waived by the individual, but that, otherwise is pretty much the hard line. The individual at that hearing can admit or deny the allegations, sort of like they would in a criminal trial. However, if the individual is determined to be unable to understand the consequences of an admission or denial, the court will enter denial and proceed with the hearing. And that is going to be on the judge's discretion, essentially, as to they look at the facts and information and make a determination whether they think the person can understand what they're doing. Because any admission has to be free and voluntary. And the judge also has to determine that there's sufficient factual basis to support an admission before they can order the person to treatment in custody. So that's a pretty high bar. I think most judges tend to err on the side of caution, and they proceed with the hearing, which basically requires that both sides present evidence for the court to review and make a finding. Just because then the judge will have all of the facts to consider, presented to them, which is nice. So at the adjudication hearing, the burden of proof is clear and convincing evidence that the subject needs court-ordered custody. This is a standard that is more than preponderance of evidence, which is more likely than not, essentially. This is on its face, the weight of evidence is in support that the individual needs court-ordered custody. And so it's a pretty high burden of proof in that respect because the court is restricting the individual's ability to move in the world freely. Next slide, please. So at the adjudication hearing, the rules of evidence apply. Now, from the provider's perspective, you're probably like, what are rules of evidence? It's not super duper important, but essentially the rules of evidence are when you're watching crime shows and they say things like objection, hearsay. Those are the rules of evidence. They say that certain evidence cannot be considered by the court because it is not considered credible. And the rules are all designed around that idea of like what evidence is credible. So usually things like hearsay are not allowed. Evidence can't be submitted without foundation, which basically means you have to explain what the evidence is, where it came from, why is it credible, and things of that nature. So once all of the evidence is provided to the court then has to determine whether the burden of proof has been met. If it has not been met, then the petition will be dismissed and the subject released from emergency custody. If the court finds that they did meet the burden of proving the individual is developmentally disabled and dangerous, the court will order the department to evaluate the subject and submit a plan for custody and treatment within 30 days of that order. The matter will be set for a dispositional hearing following that custody and treatment plan, and it's usually scheduled within 15 days of the department's plan being submitted. Now, Tessa will tell you, usually even before the adjudication hearing, the department has already started working on the plan, because this is not a very lengthy time period for them to try and come up with different providers and making sure that there's availability with providers. And so, this is something that the department usually is already working on from the initial petition, just so that they can have all of the ducks in a row by the time we get to disposition hearing. Next slide, please.
You're exactly right. So the second I find out someone is eligible and meets that criteria, even if it's before I have turned in my official report to the court, I will start doing what I can to get a service coordinator assigned and get the ball rolling on starting referrals as soon as possible, especially if it's someone who has not previously been in services.
Yeah, and I think the next slide is talking a little bit about that plan. Is that right?
Yes. Well, this would be the plan after there's the initial report. And then this would be the plan they ask for at the adjudication hearing, which is the plan for custody and treatment within 30 days of the adjudication hearing. So.
Great. And so Tessa will walk you through how that's completed, but essentially this plan needs to be shared with all of the parties as soon as it's completed, which means the court itself, the county attorney, and defense attorney. And if there is a guardian ad litem with them, so that way everybody has an opportunity to be heard on their opinions about this plan. Go ahead, Tessa.
So after the initial evaluation where we identify risk and eligibility for services through developmental disability, the psychologists, with input from service coordination and agency provider staff, if we've identified a potential agency at that point, I work with them to kind of develop this plan. It starts off with a history of past treatment, an evaluation of his developmental disabilities or hers, an analysis of risk, treatment and staffing requirements, as well as appropriate terms and conditions to provide custody and treatment. I'm supposed to technically identify an appropriate treatment program. I will say I don't recommend specific agencies by any means. In fact, I try to request that we do not list specific agencies in the court order, especially if something happens, it's a lot harder to change that to another agency than if we put more specifics about the site, but not necessarily a specific provider in there. For this, we often recommend that individuals under DDCOCA be placed with a risk provider, or at least a provider that could get a clinician to consult on the specific case. This doesn't mean that just because someone is under court custody that they're on the behavior risk tier. It's more about the experience of the providers in combination with the accessibility to a clinician if needed. The majority of the cases I've seen come through court custody have a developmental disability in combination with a mental health diagnosis. So oftentimes having that clinician back up, even if it's not necessarily needed, it's available, is why we recommend those. It's also in the cases where maybe we start out with someone at 1-to-1, we could increase if needed, depending on the client's needs. If they move in and situations get a lot worse, and let's say the individual starts escalating because he doesn't want to participate in services, we could potentially petition the court to go up to a risk tier without having to move him to a different agency. So it allows for a little bit more coverage of risk. In this, I will also say I do write these differently for individuals with guardians and individuals without. For those individuals who do have a legal guardian, we do try to tend to be less restrictive in what we're asking the court to put in the order, as the guardian can help support needed restrictions in other areas. We tend to focus only on restrictions required around the specific risk that got them under court custody to begin with. So there will be a certain supervision level in there, but the guardian and the team may be able to have more control on within arm's length or within eyesight, or a 5-minute bathroom break and who's standing where. That's not necessarily in the court order. The guardian can improve those more specific restrictions. If he was in for arson, I would definitely want to put in some fire restrictions, fire starting restrictions in the court order. And maybe he just has a problem staying up too late playing his video games and not getting enough sleep. That's not necessarily related to the arson or the risk, but we may need to limit game time in the evening. That could be something that would be still under the guardian's purview. So because of this, for those with guardians, these may look a little more sparse. For those without guardians, however, we do tend to focus on whatever restrictions we need being in here in order to validate and get court approval, since there's not a legal guardian to approve those restrictions. So in this case, we might have to petition the court to restrict the person from video games after 10 p.m. at night, even if it's not related to the risk, just because we might need to actually get that approved. So for that reason, in those cases without guardians, we really try to focus on any and all restrictions we may need, including things like lock sharps, because it's a restriction for a housemate, so we have to get it covered for them.
So at the dispositional hearing, the court is going to consider the department plan that has been submitted, all the arguments of parties, and any other relevant evidence that is submitted. This is the one hearing under DDCOCA procedures where the rules of evidence do not apply. And so it'll be sort of up to the judge as to what evidence comes in and what doesn't. I think they generally are going to err on the side of considering everything that is credible, essentially, in making their decision. The department plan is generally going to be approved unless there is a preponderance of the evidence determination that the plan is not the least restrictive alternative, which would mean that the defense counsel or the county attorney would have to put on sufficient evidence that there is another plan that is more effective and least restrictive, essentially, or equally effective and less restrictive. And so that's sort of important because a lot of the time, that is the plan that is submitted. It's the only plan considered. And then it's just arguments as to whether or not that plan is appropriate, but not necessarily a counter plan that is offered to the court. When the court issues their order, they will include disposition wherein the individual's custody is placed with the department, as well as setting forth the treatment plan. Now, they can either set forth the treatment plan in the order, but most of the time they're just going to say the treatment plan dated blah da da, is adopted as if set forth in this order completely, which is sort of annoying in the sense that then you need to have both a copy of the order and the corresponding treatment plan, and you're looking at two different documents rather than one document that contains everything. And a lot of that is just because the treatment plan, they don't want to attach it to the order because the order is part of the public record. And we don't want, obviously, people's private information to be part of the public record, and the treatment plan would contain, private information. And so it's usually going to be kept confidential as a separate document. So just, FYI, you might have to make sure you have both copies as a provider on file and put them together as if they are one document for the sake of, being able to look at the order to follow it. The duration of the court ordered custody and treatment can be no longer than a year. And this gets to the requirement that review hearings happen at least annually, is that the commitment of the individual to the department's custody can only be ordered at maximum for a year term. And so, bare minimum, it needs to be renewed once a year. But usually the courts are doing their hearings more often than that, and they renew it a little bit more frequently at those review hearings. Next slide, please.
Before we go on real quick, for any providers who may be looking for a copy of the treatment plan, service coordinators should have access to it. It's loaded on a SharePoint drive that service coordinators can access. So feel free, and it is often not even labeled treatment plan, but exhibit number or something. So feel free to reach out to the service coordinator, and they can work with us and make sure you have that copy of the treatment plan if needed.
Right. Thank you. So following court orders, every court order is basically from on high, if you will. And failing to follow a court order can lead you to being held in contempt, to be punished by fine or imprisonment if it's willful disobedience. And there's just sort of not a good feeling of the judge calling you in to court to answer for the fact that you have not followed a court order. Whether or not they do impose any actual fines, it's just getting called into the principal's office sort of feeling. It's not a good time. As we were just discussing, sometimes the courts are very thorough in their court order, but sometimes they're not. And so if there's ever a question as to what the order says or what the restrictions are, or whether or not something should be allowed because maybe the court order doesn't even reference it, it is a good idea, if not the only good idea, to reach out to the division and the service coordinator and have a conversation. Providers are surrogates for the department as contractors for the department. And so if you're not in compliance, the department's not in compliance. It's not a situation that any of us want to be in. And it certainly puts a strain on our contractual relationship. And so it's better to just have clear lines of communication when there are questions or uncertainties. We may not always be able to give you advice about what you should do, because sometimes it might be that you need to seek, legal counsel for yourselves. But if it's a question of what does the department want you to do to follow the order, that is usually something we're going to be able to give you a clear answer on. But you always want to make sure that you're documenting things, especially when it comes to court orders. So, for example, if there's a lapse in following the court order, we need clear documentation, triplicate that documentation for our purposes, because if there is a report made to the judge that we have not followed their court order, they're going to call us in and ask us why. And we want to be able to show, here's the documentation, here's the incident that happened. And if it was our fault or the provider's fault, if you will, here is the plan to address it so it doesn't happen in the future. But I would say most of the time these lapses are due to, misbehavior of the subject or the patient. Like say, for example, they elope, and we had all the right protections in place, but they managed to, sneak out a bathroom window or something. then we say, this is what happened, this is what we did in response, here's all of our documentation. In the future, we're going to have locks on all the windows or alarms on all the windows or whatever the process or the procedure would be to address that issue. And so that is how we want to make sure that we're always in compliance with the court order. And if we're not in compliance, but not through, any intention, we've documented what happened sufficiently that we can explain ourselves.
Accidents happen, people call in sick, the worst situations always happen, but as long as we can explain, or maybe it is, the individual keeps eloping, maybe we need to enhance the plan. Open communication is much better, and documentation is much better than having the court question.
Mm-hmm. Exactly. And we're going to talk a little bit more about like what to do if there is a big event that requires, a response. But just generally, even if it's a small thing, like say the restriction says there should be locked sharps, like Tessa indicated, and there was a day that it was discovered the sharps weren't locked and nothing happened, nobody was hurt, still document it, so that way it's in the record and there's no question about, this is what happened. We took care of it. They're now locked. We're double checking every day, whatever the case may be,
The other benefit of documenting something like that would be to potentially look at reducing restrictions. Look, it was an accident. It was unlocked. We fixed it, so it's not anymore. But during that time, there was no issue.
Yeah.
It can be good on both sides.
Right. And we know it's a pain to document everything, but better to document it and have your bases covered than have to have an uncomfortable conversation about what happened and people can't remember because there's no documentation. So I believe now Tessa's going to talk a little bit about progress reports, which are an important part of this documentation because that's where some of that comes in.
Yes. So how do we typically get information back to the court? Once they are after that disposition hearing, we basically try to refer that to that date as their annual hearing. It never quite works out with most courts that we can keep that the annual hearing, depending on how often they schedule hearings. But the ideal would be that's their annual hearing. 3 months from then, we will submit a quarterly report, 3 more months, and then the annual at the end. These are written by service coordination in combination with the clinical team. So these are not something providers have to write, but it's good to be aware of because service coordinators pulling a lot of that information from the documentation you create. This starts out with all of these should be the same with the table at the top about all the people in the court. The second table is more about letting the court know exactly where the individual is and who they are with. This is actually in an effort to help keep them aware of where a person is living without having to put a specific address in the court order, which historically has been even worse than a specific agency, because if that something bad happens in the house, black mold, and we have to move them overnight, all of a sudden we're out of compliance. So I do try and make it more general just for those accidents. But this way it's in here so they know exactly how to find the person. We do split up team approved restrictions as well as the current court ordered services and restrictions. This is really important for those individuals who have their own legal guardian. We want to make the court aware of the entire supports that this person has. So even if it's not in a court order that someone has locked sharps, we want to let the court know that this is in place. And this is in place without you. Like, we don't necessarily need the court at that point for that specific restriction. So that way it stays out of the court order, but they are more aware of what's going on outside of that specific risk. Most of the time, the individuals who are their own guardians, this is going to be NA. There's a brief summary of residential and day services. Honestly, this is meant to be an extremely general description of the environment and typically won't change report to report unless there is a big change at work or they move or something, get new housemates, for instance. In this report, any recommended changes that we want to make to the court order, which the team would be in discussions with service coordination about, service coordinator will put those recommended changes in the top of this form. This form is then reviewed currently by myself, but will be reviewed by someone from the clinical team, most likely a psychologist, and then sent off to all the legal parties. So when I review these, first of all, I'm typically in conversations with the service coordinator before the recommendation is even finalized, to kind of talk to them about what might be most appropriate with the courts. But I do, at the very end of this document, have a section where the clinical support team can respond and provide support and justification as to why either increased restrictions or decreased restrictions are warranted. These communications are sent via secured email by the clinical team. They are typically due when, whatever month they're due, they're typically due on the last Friday, or at least 2 weeks before the hearing, if there is a scheduled hearing. And I think we talk about changes later. So we will talk more specifically in a couple slides on what that process looks like when we're requesting changes to the court order. Accidents happen. People are smart, especially some of the people who are under court custody, have been in bad situations, have learned how to kind of manipulate situations to their benefit, even in cases where it's inappropriate manipulation. Stuff's going to happen. In most cases, there's going to be some sort of event that happens that we'll probably want to tell the court about. This be any high level incident that needs to be reported to the service coordinator, who will then report it to the legal parties. These could include things like a significant breach of the court order. Let's say the person eloped and we can't find him even with cop involvement for 2 to 3 days. If they were left alone because staff called in sick and no one checked, so they were by themselves all night. It could be if they had contact with law enforcement, psychiatric hospitalization, or significant behaviors related to whatever their individual risk is. So if it's history of pedophilia and they have age-inappropriate sexual material found in their room, that's something we probably are going to want to report. These do not have to be reported the second they happen. Probably should, to the service coordinator, report it as the second they happen, but we do not have to report it to all the legal parties that very second. Service coordination after these events will discuss with clinical team and legal team about when would be the most appropriate time, depending on the exact situation. So let's say if someone was psychiatrically hospitalized, we think they'll probably get released in a day or two. Everything is safe right now. It may be a better idea to wait and contact the judge and attorneys for DDCOCA until that person is back home and we can kind of ensure everything's stable. It's not multiple emails saying, yep, she's still in, she'll be released tomorrow. Whereas if we have someone who elopes and is gone for, let's say, more than 24 hours, or someone we know has a history of, let's say, inappropriate sexual or fire starting or impulsive behavior, that we have concerns about them being outside of supervision, we may want to notify the legal team almost immediately, especially if maybe we need help in trying to locate the person. These decisions, though, they're not ones you have to make by yourselves, so feel free to reach out and discuss with a service coordinator. Service coordinator will reach out and discuss with clinical team and legal. One of the most important things about this, though, is each notification should also include a plan to try and reduce the risk of a similar event happening. So it doesn't matter what the cause was. Maybe they were just super quick the second the staff walked in the bathroom for 2 seconds and they're out the door. Maybe it doesn't matter whose fault it is. How can we reduce the risk? Because that risk to the community is the court's number one concern. So let's talk through a few possible examples of that. Joan Ark had an incident where she eloped from her residence, ran to a gas station, and stole a bottle of liquor. She then ran to a nearby park. Police were notified and arrived at the park as staff were also arriving. Now, facts about her. She's court-ordered to have 2 staff remain visual during all waking hours. She's also ordered to abstain from alcohol. This specific night, one of the evening staff didn't show up for a shift and did not call. While there were still 2 staff in the home that evening, the second staff was present to support Joan's housemate, who requires 1-to-1 staffing. So, as far as a potential plan would go, there was a breach in the court-ordered level of supervision, which likely led to the success of Joan's elopement attempt. While explanations are good, it's more important that we create a plan to try and reduce the staffing issues in the future. So this could include things like having an on-call staff on backup for similar emergencies. It could be potentially including a request for changes in the court order. For instance, maybe 1 staff with alarms on the doors and exits might be more beneficial and reliably available than 2 staff. It might absolutely depend on the situation. It's more a matter of how do we reduce risk and how do we ensure we're following court order. So, for example 2, we have, while doing a weekly search through Captain Kirk's phone, staff found that he had downloaded a social media app and was attempting to communicate with someone who he had previously sexually assaulted. So, a little bit of history. Captain Kirk is court-ordered to not contact this girl and not allowed access to any social media. His phone is searched weekly by his residential provider to look for any inappropriate contact or apps. So in this case, even though staff were following the plan appropriately, Captain Kirk chose not to follow his court order. Such situations, especially if repeated, would likely involve a request to change the court order, possibly either increasing the searches of the phone or decreasing his access to the phone. Are there things we need to add to the plan now that he is testing the environment potentially? Are there supports we need to add to the court order to help ensure that those significant events don't happen again?
Just to interject, Tessa, I want to point out this is also one of the cases where this is more likely to be a big issue for the court, because the victim, if she is contacted, is likely to contact the county attorney and be like, why is this happening? What is going on? Because, she's traumatized, or her family, whoever, you know what I mean? And so it is likely that if the county attorney hears about this first, that's a bigger problem than if we bring it to the court and can explain this happened, we've taken these steps. And so this one in particular, I just want to raise as, this is one where we need to make sure we're talking to service coordinator as soon as we know it happened, because we need to get out in front of it if possible.
And there have been times, there was at least once I was contacted by the county attorney in almost a similar situation. And while it's unfortunate to find out that way, and we never want to find out through the county attorney, this guy was kind of really sneaky. So they weren't even quite sure how they were doing it, but the provider was able to go and figure out where he got access to a phone, actually from a friend at the Y, apparently. And then looking into it so we can reduce it down. So no matter what happens, document as much as you know, document that you are doing your best. And if something falls through the cracks, it's more important to not find excuses, but find ways of reducing the risk. So he got it from his friend at the Y. We're not going to go blame the friend at the Y. We're not going to do anything like that. But maybe he doesn't get to go to the Y as often, or maybe he has to go to the Y when his friend's not there. They go to a different YMCA, things like that. It's how are we going to fix it? And yeah, please don't let me find out from the county attorneys and then I have to call you and you have no idea and are providing excuses. Because in that case, he may just take you to provide your excuses in front of the judge instead of me. Okay, so when we want to request changes in the court order, this could be all of a sudden Captain Kirk is getting more sneaky on his phone and we need to ask for either daily searches or maybe some sort of monitoring app on his phone that staff can monitor what he looks at in real time. Or whether it's someone's doing great, let's reduce the 1.5 to 1 to 1 to 1, or let's give them a little bit of alone time in an appropriate spot. Maybe it's 15 minutes of break at work or, 15 minutes alone in his room at home with the door shut rather than having it being opened and constantly visual supervision. Whenever we want to request those changes, we need to document those in the quarterly or annual report along with our rationale for the change. Now, these technically are only every 3 months. However, if we want to request changes between the quarterly reviews, that is still possible. This is something if we work with through the service coordinator, we can do an addendum basically to our previous report and request those changes as soon as we see we need them. It probably would be more important in the cases where we are talking about increasing, where it's more of an immediate need, but it is a possibility. So when we write this report and are requesting changes, there are 2 different ways. If there is an upcoming hearing, we will send out a report. I usually write in big red letters, requesting changes, document the changes that we want in the email, as well as attaching our report to the email, talking about the changes we want, asking them to reach out for questions before the hearing if they need to, and then the judge will make a decision at the hearing. When there's not a hearing scheduled in the near future, so let's say someone just came under court custody in January, their next hearing is scheduled next January, but we realized when we put him in, we gave him 2-to-1 staffing and he really does not need 2-to-1. He would be absolutely fine with all the other structures in place and 1-to-1 staffing. But there's not a hearing scheduled for 6 months. We can still request those changes. I write up the email the same way, making those changes absolutely clear in the email. And I ask all the legal parties, defense attorney, county attorney, and guardian ad litem, if involved, if they would be supportive of the changes. If everyone supports the changes, a stipulation to the court order is written and submitted to the judge for review. This stipulation can be written by any of the attorneys. It's usually a conversation just in the email about, okay, who wants to write this up? When someone does not support the changes, which has happened, we're asking for an increase in staffing and maybe trying to restrict access to their money to keep them from purchasing alcohol. That might be something a defense attorney would definitely push against given the restrictions. It's not that that change is immediately thrown out, that request. In that case, we would request a hearing where this is discussed and reviewed in front of the judge about what restrictions are we asking for and why specifically are we asking for these. Now, one of the biggest things is we must have the new court order approving the changes before the actual changes are made. So whether this is, in the case where the court order said they were in this specific shared living provider home with a specific address, and a shared living provider quits, the agency still kind of has to provide services. But technically we can't really move the person until the court order changes. Obviously, in extreme circumstances like the one in the black molds, the court would be accepting of that excuse as long as we gave them information as soon as possible about the situation. But we really, if we're talking about increase in supervision level, decrease in supervision level, we want the new court order before we actually start doing any of that.
So, as we discussed earlier, review hearings are held at least annually, and this is by statute. However, a lot of counties will do them more frequently, like say every 6 months. It just sort of depends on the county and the judge, how frequently they hold them. Previous to the annual review hearing, which is, sort of a redisposition hearing, if you will, the department will submit an updated plan. Now, I think prior to almost any review hearing, we always try to have an updated plan in custody and treatment for an individual, just so that there's evidence to be considered at the hearing. At the hearing, the state still has the burden of proof to prove that it continues to be necessary that the individual is under court-ordered custody by clear and convincing evidence. I think we see a lot of the time with these DDCOCA cases that because developmental disabilities don't really resolve, they do tend to be long-term cases, by which I mean they last for at least 2 years a lot of the time. Tessa could go into more detail about, sort of the trends from that perspective, but sometimes closing a DDCOCA case can be difficult by virtue of, the risk is always possible, and so sometimes it's hard to convince the parties that just because it's possible doesn't mean it's likely. But that is supposed to be the county attorney's burden to prove that it continues to be necessary. And then the defense attorney would have the burden of trying to disprove that argument, right? And sometimes the division does get involved in that conversation just by virtue of we don't think the court-ordered custody is necessary from a treatment perspective anymore, and we might make a recommendation that it be dissolved or dismissed. So the court will continue or modify the court-ordered custody and treatment, or may vacate the custody and treatment and dismiss the matter entirely. I think most of the time we do see modifications at these hearings. As we sort of have indicated, a lot of the time those modifications are just an adoption of the new or most recent report from the department and treatment plan that goes with that report. And so, it can be sort of tough from the provider perspective of figuring out what the court order says, because it's, again, embodied in sort of two separate documents.
Reach out to service coordinator. Mm-hmm. Any questions, reach out to service coordinator. And Just to make it clear, the updated plan for custody and treatment, that is our annual report, includes all that information. So it's not two separate documents. It's that quarterly or annual report that is submitted that includes all that information.
Next slide, please, Tessa. And so the other option for a review hearing, so the ones we were just talking about are basically at the court's own action. They've scheduled that hearing, they've set that hearing just as a matter of bringing the case back up for consideration. A party can at any time also request a hearing with the judge, wherein we could review restrictions, modifications, or even whether or not the DDCOCA is necessary. And so a party can request a review hearing if it appears that there is no longer a threat of harm to others, the custody and treatment plan is no longer sufficient, or maybe there are new, less restrictive options available to the person if they're doing well. Or there has been a significant change in circumstances, such as like they need to move providers, or maybe their health is deteriorated and they need a higher level of care. You know, it could be any number of things. Whoever is filing the motion, that's what a moving party is a person who has filed a motion. They have the burden of proving by preponderance of evidence that what they're asking for in terms of dismissal is, you know, the right decision for the judge. So if they want the case to be dismissed because the subject no longer proposes a threat of harm, then the burden of proof is the preponderance of evidence, which, as I said earlier, is basically a more likely than not level of proof. If they want to modify or vacate a custody and treatment plan, then they have to present counter evidence by clear and convincing evidence. So they would need to have, you know, documentation as well as maybe their own treatment plan or restrictions and things that they are proposing in order to convince the judge to order what they're asking for. It's sort of important to note that the reason why it's a preponderance of the evidence is because these cases, as I said earlier, sort of are not necessarily weighted in favor, I guess, of the subject's freedom in a lot of ways. And so by having that lower burden of proof, it allows them a little bit more of an ability to not be subject to court custody forever. But then also, a lot of the time, because of the restrictions and safety plans that have been put in place, proving there's a threat of harm is sort of a hard thing by virtue of the context, where it's like, well, they haven't engaged in any harm, but we've had all of these precautions in place. So how do we know without those supports that they wouldn't? And so it's sort of this kind of difficult question, I think, to present to the court sometimes from the defense perspective of, well, they wouldn't, not because of those supports, but because they have made meaningful progress with their treatment such that they no longer are a threat, say, for example, of lighting fires, because part of their treatment has been understanding the danger of doing that, and that has been made, you know, clear to them, and they understand now that that's not something they should do. And so even though there are supports in place and, you know, safety plan that says, you know, that they can't be around flammable materials or lighters or, you know, anything like that, even without those in place, they still would not engage in that action. But that's sort of a tough argument, as you can see, because it's very hypothetical. And so I think that's part of the interesting conversation about the different burdens of proof here.
I think part of this too is just like sometimes education as well. Like, because maybe all of those supports would still be in place due to a legal guardian now being able to sign off and permission for those things, where maybe there wasn't one in place at the time of the custody incident, or, you know, there's a lot of different potential arguments and situations like this. And I will say, anyone who's really interested at reducing either restrictions on a specific court custody case or potentially looking at getting it dismissed, reach out to the service coordinator. I've been working with a few different ones on trying to kind of create plans to document what we need in order to potentially have that dismissed, or at least reaching out and talking to the legal team, educating them on what would still be in place without the court involvement.
Yeah, as Tessa's sort of indicating, sometimes defense counsel or the county attorney aren't aware of the services that would still be provided absent the court custody. And so sometimes it is a matter of, just explaining DD eligibility in general, and what services kind of fall under that. And that usually is not something those professionals have as much experience and knowledge about.
Or even awareness that services can continue after court custody is removed. Like, this person is eligible, they're on the waiver, guardian or not, maybe they're willing to stay in services. So, like, even just that awareness that I know I had to testify with one judge who was concerned that this individual would lose services. They were in services before the incident, they were on court custody for about 10 years. Interestingly enough, only 3 high GERs that whole time, but still court custody because the judge, and she told me later, she was concerned that his funding would be pulled and then he would not have the supports through DD, and then he could potentially be a risk again. So sometimes it's just even educating them.
Right, right. So I think it's an interesting conversation. And one of the things to keep in mind, because maybe it sounds like I'm biased, um, we are not in the business of trying to, close DD court custody cases or anything like that. But sometimes the DD court custody can become sort of a barrier to services, if that makes sense, because um, it's not as flexible as regular treatment would be, where we could work with the individual because we have to get a court order for everything. And so when you need a court order and you can only get those, through a hearing, you have to wait months. And, so that's not a very flexible way of being able to do things. And so sometimes it can work not in favor for individuals who are making progress and need a little bit more flexibility in what's going on in their lives. And feel free to talk about that if you'd like to, Tessa. But that's sort of my perspective from the outside legal.
Well, I can tell you from my perspective, it's kind of opposite. My goal is to reduce this as little as possible. But I want to get most of the DD court custody cases that we can dismiss, but it's all based on what we can, what is safe. There is definitely a need for it, like, especially individuals who do not need the assistance of a legal guardian, and do fairly well, but have certain risk factors that they need help controlling. I think in a lot of these cases, it tends to be kind of more inappropriate sexual behavior and or substance abuse accessing it, and then behaviors resulting from that. So there is a valid use for this in a lot of cases where those individuals can still make as many decisions as they can, being their own guardian, but we also have a little protection in regard to the risk. But if we're looking at least restrictive and someone doesn't necessarily meet the criteria for court custody and that high level of supervision and risk, it's more restrictive than what we need. And looking at least restrictive, I'm going to fight against it. So,
Yeah, that's fair. So with that, thank you so much for listening to our training. And we'll turn it back over to Tanya, who will give you some more information about if you have questions, who to contact.
Thank you. Thank you, Charisse and Tessa. If you, as it says there on the slide, for case specific or participant specific questions or concerns, please reach out to the assigned service coordinator.